Um, and then, like I said, normally I'm in the studio usually 15, 20 minutes early. And I usually go over and I look at things, or I make sure that I've got all the topics and everything addressed, and things like that are ready for the show, kind of a thing. And so not
Okay.
so much today. And so we'll see who all jumps on and hops on. But anyhow, um, welcome to Spray Wash Land, everybody out there. As a quick reminder, if you don't remember, this is attorney Roland Sennholz, if I say it correctly, Esquire. And he is with, what's the name of your law firm again? Argent Law Firm, I think is what it is.
Argent Place Law. Yep.
Argent
That's
Place
it.
Law, yeah. And
We're in Northern Virginia.
last time we had this discussion, and boy, we went on for almost 2 hours, I think we were talking about, and it was just great topics, great discussions, and we said we would do this again, and he's been so gracious. So again, let's go ahead and introduce yourself again, and let's start there again.
Okay. Hi, everybody, or at least Jacob. My name is Roland Sennholz. I am an attorney. I'm licensed in Pennsylvania and D.C., but I'm actually working with a law firm in Virginia, Northern Virginia, and we help entrepreneurs with all of their business law needs. So whether it's starting a business, LLCs and that kind of thing, running a business, contracts, trademarks, the whole works, or selling a business, right? The due diligence around the sales process, or shutting it down, passing it on to the next of kin, whatever you want to do with it. We help with all of the paperwork around that. So
There you go.
Good to meet you all.
So, and just so that you know, we stream on several different things. So we've got my page, Ray's page, YouTube, couple of YouTube channels, all that. So depending on which one it's showing you, it shows you up in the corner, probably right there.
Yep.
That depends on which stream it's showing you. So there's several different ones. Some of them might say 10, some of them might say 20, some of them might say 40, whatever it is. So ignore that number a little bit. Anyhow, unless it's just Jacob, then we don't care about Jacob. Jacob's just, Jacob. But anyhow, we love Jacob. If you can't tell.
Hey, I don't know Jacob. I'm just happy to have an audience.
There you go. Look, so actually a good way to start this off, and a lot of these will get Facebook user like this, because it's StreamYard's not catching who they are for whatever reason, and we don't know what platform or why, because sometimes they come through and they'll make a comment and it'll come through as Facebook user. So, but we always try to address all of them. So, one of the things that I think would be a good place for us to start is kind of what I was talking to you about pre-show, and that is, a lot of times people go out and they'll hire a web firm to build a website for them, and in that website building, the web developer might ask you some questions, or whatever, and then if you don't really know what you want, you say, just build me something, right? And so there's some inherent problems with that if you don't know exactly what it is that you want, because now you're asking a developer who may or may not have questionable morals and ethics, as we found out with ours, right? So we recently had where a web developer was looked like targeting pressure wash type companies, and they were using some of the Spray Wash logos. They were using the Spray Wash Pro logo, and they were using the certified one of our certified logos. And so we put them on blast like very quickly when we found out. And I physically called the guy. I don't generally lose my cool, and I definitely lost it with him, because that's not cool. And I let him know that you are stepping over a legal boundary, that you are about to get hammered as hard as we could. So share some thoughts that you might have on just maybe hiring somebody. That do you really need to worry about what they do since it's your website, or how would that be?
Yeah. Okay. So there's a lot there. I guess I'll start from the beginning, right? When you hire a web developer to create something for you, you want to make sure that you have a good contract with them. so that you know what you're actually getting, right? If they agree to set up the website for you, they could frame it, depending on what's in the contract, they could frame it as a service. Look, we're going to set up this website. We're going to maintain the website. You're not actually going to own the website. Or they could set it up as like a good, right? They're providing you with a website. They're going to turn it over to you, so to speak, and then you get to own it. You get to maintain it. You get to host it. You get to do all this other stuff with it. All of that is going to be laid out, the details of that contract. You're going to want to make sure that you have someone who knows what they're doing look at the contract and make sure you're getting what you think you're getting. Okay. If you don't even own your own website, there are different things that you can do with that website than if you do. And that's less on the trademark side of things. That's more on the copyright side of things. If you want, I can do like a quick breakdown of what different kinds of intellectual property there are. But otherwise, I'm just going to keep rolling because there's a lot in those facts.
Just roll. What I'll do is I'll make some little notes as you're talking. So when I'm looking down, I'm not ignoring you. I'm just making notes so that we can cover a few topics. So go for it.
Okay. So once you've hired this guy or company, whatever, with this contract that hopefully says what you want it to say, then they get to go out and they do their thing, right? They make a website. Hopefully, you know what you want that website to look like. I recognize that there are a lot of people out there who do that thing of like, well, I don't really know what I want on my website. Just make me something. That's kind of like going to an airline counter and saying, I want a ticket. Well, where do you want to go, sir? Oh, I don't care. Just give me a ticket.
Send me anywhere.
Okay. Yeah. Okay. Okay. But okay. So let's say, so you ask them to set you up a website and they go out and they, hopefully they're on the level. They do everything right and everything's good. We're not going to assume that here. We're going to assume that they go out and they take somebody else's stuff. Could be a logo, could be a graphic, could be a picture, whatever, right? And they put it on the website, on your website, as they're setting it up. There are two questions there. There's a copyright question is kind of the main question, and then there's also a trademark question if they borrow someone else's logo like they did with you. The copyright question is if you have a picture, if you have a graphic, if you have some kind of an image, or it could be a sound file or other things, but usually it's an image, right? Then do they own or at least have a license for that image to use it the way that they can use it, or the way that they're trying to use it, right? Mm-hmm. So a lot of people will pull stock photos off the internet because there's a copyright license there that says you are allowed to use this as long as you use it a certain way. Okay, good. As long as you're complying with the terms of the license, that's good. Or if it's a picture you took yourself, you own the copyright, you're welcome to use it however you want. If you give it to the web developer and say, hey, use this picture, they'll say, sure, you took it, it's yours, no problem, right? But if they lift somebody else's picture and they don't have permission to use it, okay, now that is technically a copyright infringement. And the bad thing about copyright infringement is it doesn't matter who did the infringement. They can still come after the person who's actually infringing. Okay, so if you hired this web developer to set up your website and they used someone else's image without permission, the company or person who owns the copyright can still come after you because it's on your website, even if you weren't the one who actually put it on the website. You're still violating their copyright by having it on your website, right? This is the same way that a lot of YouTube videos get taken down, right? Someone has a clip with like a 30-second. There was a famous incident where some lady had a picture of her baby dancing to a 30-second clip of a Prince song. And they tried to get it taken down because they said it's a copyright violation, right? She's playing this Prince song, and it's not hers. She doesn't own the copyright. She doesn't have a license. She's violating our copyright. And there was this big battle over it because, really, what was the point of the video? It wasn't to just play the Prince song.
It wasn't trying to make any money or doing anything with the Prince song. It was just
exactly. Which, by the way, doesn't make it not a copyright infringement. It just potentially means that it falls under fair use, which is an exception to the otherwise to copyright,
because it wasn't being used for a commercial purpose.
Yes. So basically, it's not that it wasn't a copyright infringement. It was just an acceptable copyright infringement because it fell into one of the exceptions. So, but in any case, to bring it back to, like, what if someone just slaps an image on your website that's not theirs and that it's not yours? Well, then they can come after whoever they want, right? They can come after you because you're doing the infringement. And okay, theoretically, then if they win against you, you can turn around and sue the web developer if you've got something about indemnification in your contract with them, which you hopefully do, right?
That's why it's important you turn somebody to look at the contract.
Yes, that's right, exactly. But that also assumes that they have money, right? If you're going to turn around and go after this web developer, there's a chance, right, that you actually are a deeper pocket than they are.
They are.
I mean,
yeah, and that's kind of where it is. So in that case, like in our case, we wouldn't necessarily go directly after the web developer. We would go after the website owner, and then the website owner would have to go after the developer. Or could we go directly after the developer because he put it on there?
So do you mean the copyright owner? Could he go directly after the developer?
No, could we, like, you hired somebody to make a website and they infringed on us? Can we then go after them instead of going after you? Or do we have to go after both?
Instead of going after me.
Because you own the website, but you didn't actually do the infringing, even though you are technically the infringer. You see what I mean? Because
okay.
Your website.
So usually the copyright owner can go after the person who's doing the infringing, meaning if you got it on your website, no matter where it came from, they're probably going to come after you.
Right.
However, you can then go after the person who caused the problem, right? You can go after the web developer because they were the ones who caused this infringement by their negligence, by their intentional misdoings. They whether it was an accident or whether it was on purpose, they lifted somebody else's copyright and put it on your website. So you could go after them for that, typically.
So one of the important aspects of this, and backing up just a little bit, is that you were talking about making sure that you own the website, and this is something that's really important and something guys don't think about very often, and that is when you hire somebody to build a website for you, and they say, okay, what area are you in? Let's just say, for example, I'm in the greater Baton Rouge area, and I say I'm in Baton Rouge and I do pressure washing. And so they type in pressurewashingbatonrouge.com, and it turns out to be available. So they buy it for you. Okay. But are they buying it for you, or are they buying it for them? And are they giving you the rights to whatever domain name that is? Right. My nieces and nephew call me Dougie Doo. I own DougieDoo.com. And let's say that they did DougieDoo.com and they built a website for me, right? But they own the web pages, they own the domain name. Now, throwing a little bit different, let's say that they say you own the web domain, but who owns the files? You see, these are things that you need to find out when you're doing this, because at the end of it, you say, you know what? They built me a crappy website. I really like the name DougieDoo.com, right? But they built me this crappy website and I don't want it, right? Now what? Right. I say, well, I don't want those, that I'm going to go with somebody else. Okay, great.
I want the domain, but I don't want the website.
Right.
Right. Okay. Now what? And have you already paid them for everything, or are you only going to pay them for part of it? Or, then we can get into dispute territory really fast.
And what does the contract say? Does the contract say they own that that domain name, or do you own that domain name? You have to. These are important things to look at.
Or is it completely unspecified and we don't even know?
Because you can't just assume these sorts of things. It's you should know, right? Anyhow,
that reminds me though. Quick, before we go on, I do want to put in my typical disclaimer, just in case you guys weren't here for the first one. Right? Disclaimer: I am a lawyer. I am not your lawyer. Please consult with legal professionals to get advice on your specific situation. Rather, use what I'm telling you today as kind of an idea of where to start looking, rather than just kind of going with what I say and some lawyer on the internet told me. So please, because I'm trying to give general situations. Little facts can show up that make a big difference.
Mm-hmm.
So your situation may be very different from the generic situation.
And as always, these are our opinions, our thoughts, our views, and not legal advice or financial advice to anybody that's out there, kind of a thing. That's where we're going with that aspect of it. So anyhow, going a little bit further with that. So on the branding side of it, what would be a thought that you would have towards what's the best way to approach the branding aspects of your business to make sure that you don't run into any copyright infringements? And I'll throw another little twist to it. I looked at a business recently where I thought, that is a brandable business, meaning I could turn that into a franchise thing. And then when I did my due diligence and started looking, I realized there's already somebody else that has a copyright on the name that they're using. They're not even using it. So there was no point in trying to do that kind of a thing.
Okay. Okay.
So they're a local. They own a local business.
Yeah, you said something there that didn't quite click for me. So you said they own a copyright. I think you might mean a trademark.
Owns a copyright or a trademark. I'm sorry.
Okay.
Yeah,
so okay, yeah. So so then that actually ties in well with the other piece of where I was going. You were talking about the logo, right? The spray wash logo, mm-hmm. and how they used it on the website. So in some cases, so with a copyright, right, you want to make sure that copyright is handled properly, because then they can come after you for copyright infringement. But the other piece of it is trademark. Trademark only applies if they take a logo, right? If they take something that doesn't, it's not just like a random image or whatever. It's actually a piece of branding, right? Mm-hmm. It's a piece of your company's identity. If they kind of borrow your company's identity, that's a violation of trademark. Trademark is not designed to protect an image or whatever. It's designed to protect an identity. Okay, so usually it's a logo or a name. Sometimes it could be a video or a color or a smell or whatever, but usually it's a logo. And so if they borrow your logo, and with your same services or goods, then they can argue, basically, then you can actually make the argument of, look, they're not just borrowing an image off my website that I created. They're actually trying to steal my company's identity. Mm-hmm. And that, okay, copyright infringement. If you have your copyright registered with the Copyright Office, you can go after statutory damages, statutory infringement damages, which are up to $150,000 per infringement. This is why the Prince dancing baby thing was such a big deal, because that means every person who viewed the video was theoretically an infringement. So multiply a couple thousand or million views by $150,000. That adds up
pretty quick.
Yeah. if you can get 150,000 by proving that it was willful and all that. But
Right.
anyway, trademark, on the other hand, is more designed to prevent that kind of identity theft, which means you can take however much money that person made off of using that logo times 3, usually, if you can prove that it was intentional.
Right.
Which can be a whole lot more money, actually. Right, assuming that someone actually does intentionally take your trademark, your logo.
Right.
But in any case, so when this guy lifted your logo and used it on his website, not only did he maybe commit copyright infringement, I'm not sure that you could say that that's enough of a work of art, right? That you could say that that's unique enough to really count as copyright infringement. Maybe, I'm not sure. But it's a piece of your company's identity, right? It is a trademark. Okay, I don't know if you have it registered federally, which would make it easier to enforce, but they are basically borrowing your company's identity and giving this idea that you have endorsed the services when you haven't. That is textbook trademark infringement. It's like, oh yeah, you take I don't know, you have a restaurant that makes burgers and fries and you slap a McDonald's logo on it. It's okay. You're not actually licensed by McDonald's. You just want people to think you are because that will lead them to buy from you more.
Exactly.
That's straight up
Not
trademark.
Yeah.
Yeah. So, so how do you protect a brand? You get a trademark on it. Theoretically, whenever you start using something to identify your company, you automatically have a trademark on it. That said, where you have a trademark is where you've been advertising, which is usually not a very big area, right? It's like this town or this city, and that's it.
You don't naturally get a national thing unless you're advertising on a national level. You get it for your area where you're advertising.
And it's much easier, rather than advertising nationally everywhere, it's much easier to just register your trademark federally, right? So the United States.
This is where this comes into play. I'm going to bring this point back up where Simple Clean is saying, I had my website done by a developer and had to make them use my own photos before and afters because every site I see is almost the same all the way around. And this is where that becomes important because a lot of the images and things that these companies are using, they're using the same ones over and over and over and over again. And so and it goes down to this one right here where he's saying how many bulldog constructions exist, right? So it's the same thing where you have so many people saying that they're Acme window cleaners, just throwing that out as an example, right? And so you have so many Acme this and Acme that and Acme this that if you're advertising locally, and I'm just going to again use Baton Rouge, then let's say New Orleans, which is just down the street, somebody else could open up Acme and say that they're different, right? Do you think that would, because they're not in the same, they're in the same state though?
Well, okay. So I guess my first piece of advice would be if you're thinking of starting a company, it might be worthwhile to have someone run a trademark search on the name before you do it. Right. Okay. So that's one of the things that our firm does whenever someone asks us to set up an LLC or a corporation for them. We, as part of that, we do a trademark search to figure out, hey, does someone already have that name so that you know you're not walking into a trap, right? That's a good idea to do. The simplest way to avoid this problem is to just pick a name that is not common, like Bulldog Construction or whatever. One of our clients actually has this problem. He has a construction company. I'm not going to say the name, but he has a construction company with a very common name. Somehow he was able to get a trademark on it. Okay. Registered federal trademark. He's the only company in the US that has that trademark. But there are about 50 companies, no, 60. I was working on him the other day. Right now we are aware of about 60 infringers across the U.S. that use a similar name. And he's in an interesting situation because he's got this trademark and it's defensible, right? It's not like the other companies can just come and take it from him, but he also can't necessarily go and shut them down. He kind of has to, he can advertise anywhere and shut down anyone who came along after him, but anyone who came along before him, he kind of just has to leave alone. And it's not really the prettiest situation.
Mm-hmm.
So it's, yes, if you can get a trademark on something, even if it's common, that can help, but it's better to just not take a really common name.
Well, let me go this direction. So first of all, Chris is saying buy your own domain name and give your web designer access to manage its DNS settings for the hosting and provide you for the website. Check for live trademarks and classifications before using, which is super important. And then going along that lines, it's also really important to not try to choose something like what we're talking about that everybody else is using. And so I want to take something that's actually real in our industry. Okay. In our industry, we have someone that created that got a trademark on two words that are commonly used in our industry, and they're commonly used in names of businesses here. Okay. I myself used the way that he has that written. Okay. And so he sent me a cease and desist. This has been years ago. And I went in and I looked up that sequence, and it's so widely used already in the industry. And now his trademark was before a lot of those people used it, but so many people were using it that I sent him something and I said, hey, my understanding of the way it is that if you go after one, you have to go after everybody. You can't pick and choose theoretically unless you offer and correct me if I'm wrong, unless you offer individual licenses to these people, you have to go after everybody. You can't discriminate and say, I'm only going after you. And so I told him to pound sand, basically. So what are your thoughts on something like that? And a lot of people are going to know what I'm talking about there. Because it's not something that he's actively protecting, right?
Yeah. Well, okay. It's not so much that you can't target one person as that if you only target one person, it is a lot easier to defend. It is a lot easier for that person to defend, because then their lawyer can say, well, okay, there are 60 infringers. Why are you only coming after us? But that said, right, you are still technically infringing their trademark. And so there's only so much, I don't know. There are enough people out there who don't necessarily check with a lawyer first that it's not completely useless or worthless to pick off one person here or one person there. You can send them a cease and desist letter, and you don't necessarily even have to threaten to sue them, right? One of my favorite tactics is I ask nicely that they change their name, or else we're going to report you on Facebook, Instagram, Twitter, all the social media platforms, and have your pages taken down. That's a lot faster, a lot cheaper, and I think more effective than starting a lawsuit. Exactly. Yeah. So I can threaten to do that, and that, because of the way it's set up, right? If one of the social media platforms does not want to get involved there, they don't want to be in the position of a judge saying, well, you have a greater claim to this trademark than you do, and therefore we are going to leave it up, even though, no, if they do that, all they're doing is they're opening themselves to be sued, and they're a much, much deeper pocket than whoever their client is. So they don't want to do that, which means if you report their stuff on Facebook, whether or not their trademark is kind of a superior claim to yours, you can probably get it taken down, which means they have to take the threat seriously, regardless of whether a lawsuit would actually work or not.
You know, that's an interesting thing because, like, let's say, for example, that you, Roland, you have a company, and it's Roland's XYZ shop. Okay. And my name is Roland, and I own Roland's XYZ shop, and I'm clear across the country, whatever. And you filed for a trademark, or maybe you didn't, whatever. Um, you may, and you find out that I have the same exact thing. And so you go to Facebook and you say, look, this person is infringing, right? Take them down. So Facebook sends me something saying, hey, we're taking down your site because you're infringing. And I say, no, he's infringing. Okay. I'm first, he's infringing. So that's an interesting thing, because then, Facebook isn't necessarily going to get involved in the middle. What they're probably
They don't want to be involved.
They're going to take them both down.
What they're going to do now, probably, okay. So what Facebook or these other sites will usually do, not always, but usually, is they'll put the two parties in touch. They'll let them talk to each other and sort it out on their own, right? They don't want to be involved. Usually, I have never seen them. Well, okay, I have once seen a social media platform refuse to take down an infringer. I almost sued them for it. And the only reason I didn't sue them for it was because I tried again. I reported the same content again, and I got a different person that time, and they took it down in 2 hours. So, so I have not really ever seen a social media platform refuse to take down some infringing content. Now, if you have the situation of a name, okay, so I mean, Roland's XYZ shop is good. I would go like one step further. We had a client, for example, who tried to trademark or wanted to trademark Praha beads and jewelry. Praha is the local language, whatever, for Prague, right? Okay, so Praha beads and jewelry. Very good. Except that there's a little company out there called Prada that does beads and jewelry. And they were not so happy to hear about this, right? And so the question is, unfortunately, whether it involves a person's name or whatever, the question usually is just who got there first, right? Whoever got there first pretty much has a claim to the name
and wins.
Yeah, whoever started using it as a trademark first. Now, you can bet that's one of the first things. If there's ever a lawsuit, that's one of the first things you're going to have to prove. What evidence do you have that you started using the trademark on this date, right? That this date that you claim was earlier than the other trademark was. What's your proof, right? And I'm sure you could get into a big fight about that too if you wanted to, but usually whenever two trademarks fight, the one with the earlier date of first use wins.
So this is actually a very interesting question that I hadn't thought about. And Simple Clean says, is it possible to dominate and buy other trademarks and become a patent troll and sue other businesses for my own profit?
Possible, but difficult. And here's the reason. If you buy a trademark, one of the things about a trademark is that in order for it to continue to exist, you have to keep using it. Okay? If you stop using a trademark, theoretically, even if it's registered with the Patent and Trademark Office, it stops. It ceases to exist. And so if you go around and you buy up a bunch of trademarks, you have to keep using all of those trademarks if you want to be able to sue someone with it. Why would you advertise under 10 different names? I mean, okay.
Theoretically, you'd have to run those 10 different businesses.
Yeah. I mean, you might be able to conceivably pull it off, but I guess, but then the damages that you would get would be, what if, would be what money did this person make from using that name?
Mm-hmm.
Okay,
so now you have some sort of damage that you have to be able to recover from some sort of a damage.
Right. So because it's not like copyright where it's like $150,000 per infringement, where you can just get a number and you don't have to prove how much money it actually made the other guy. That's going to be the next problem, right? Once you've got your stable of trademarks and you're using them all somehow to maintain them. Now you have to prove that this other guy you're trolling made money because of that trademark, and then you only get whatever money he made from that trademark. You don't, maybe times 3 if you can prove that it was intentional.
So in that case, it's better to actually go after a copyright infringement than a trademark infringement.
Oh yeah, absolutely. I mean, that's how do the big companies stay on top? It's one part actually having content, right? They have other people produce content and they gain ownership of it. That's what record labels tend to do, right? But then you also protect it by making sure that people don't copy your stuff all the time.
And this is a good example here where Simple Clean is saying gentle rinse. So let's say, for example, that somebody put filed for it against the word gentle rinse and was able to get that, right? And especially if they said gentle rinse as one word, right? And a capital G and a capital R, gentle rinse. And this is where the next one goes down, because it's along that same lines where, words like that are used by every car wash, every laundry, and place on earth kind of a thing,
So, okay. Gentle rinse is going to be probably hard to get a trademark on, for one.
But let's theorize that it was already granted.
Okay.
Because it's very close to that kind of a thing where it's used just like that. It's a very clear thing.
Okay. Well, then let's see. So a trademark. Okay, and I'm assuming it's with like pressure washing services. It's associated with the services here. So what if you had something like that and it was very common? Okay. Well, if you don't defend a trademark well enough, it can become generic, right? That's what happened to Band-Aid, for example. You can lose a trademark because everyone's using it as a generic rather than as your particular company. That's, it sounds like that's probably what has already happened to this guy.
I think that's where he's at with his. I think it's a dead thing because there's so many. It's such a generic term like gentle rinse that it's just virtually every company that's pressure washing, soft washing, whatever uses those terms. Maybe not exactly the way he has his thing filed, but pretty close.
Yeah. Well, plus you got to remember when you file for a trademark, you don't just file for a set of words. You file for a set of words associated with a good or service, or a set of goods or services. So to address the car wash, laundry business thing down here, maybe not. It depends on whether the services that trademark covers is only pressure washing services, or it's also pressure washing and car wash services, or it's pressure washing and car wash and laundry services. Probably it's not all of those things, which means probably your trademark would be limited to being able to go after people who do specifically what you were trying to protect with your trademark.
Right. So this one here is Facebook user says, what about a company tagline? Okay, because that is something that changes it a little bit. So that now instead of it being the name, it's the tagline. So such as doo-doo septic service, we're number 1 and number 2 in business. So how does a tagline fit into that kind of a thing?
You can trademark a tagline. Yeah. It's got to be it's got to be sufficiently unique, right? That it doesn't just give away what you do. It's also kind of unique to you, I guess. It's descriptive. It's not just descriptive, it's distinctive. But just glancing, just off the top of my head, looking at that, I think you could get a trademark on that.
Yeah, I think you could. So, and this one here, so Simple Clean, just so you know, and just so everybody out there knows, this is Ryan McGowan, and Ryan will be my guest tomorrow night, and we're going to be talking pretty much along the same lines as this topic, right? Ryan, just so you know, this has been set up for a while, but we're going to finish this discussion more from a practical sense too, and not necessarily more of a legal sense. And we're going to talk about that tomorrow night, just so you know. And our special guest will be Ryan tomorrow. Ryan's really good with questions, and so but he jokes around a lot like this. I'm registering Ultra Hunk. Can you help? Just so you guys know, yes, he actually could help you register your trademarks and do those kinds of things. So if you've got questions, what's your number? And I'll post it up here, the number of your company.
Yeah, so our office number is 703-539-2518. I'm extension number 3. So, and with federal and with trademarks, it's a federal thing, right? It's federal registration. So I can help with anyone anywhere in the U.S.
And is it against federal law to use somebody else's logo per se?
Yeah, that's what a trademark infringement is.
And my point for that, what I told you, I blew up at the guy and I told him, you are breaking federal law here, and I am going to frickin' nail you to the wall as hard as I possibly can. And he was removing stuff. And I am going, if you're watching, I am going back. I got a list of a lot of websites that you built, and I'm looking at all of them, and I'm going to see if there's more. And if I find one, we're coming. I'm telling you, it's happening. Not putting up with that game. Well, for me, it boils down to this. We have Spray Wash Pro members, and not just pro members, but people that come to Spray Wash and they pay for the education to become certified in something, and they deserve to have that logo protected, because that to me is a very serious thing. And I'm going to bust this guy's butt if he does not take it down. He is going to be broke by the time it's over with. I guarantee it, because if he has any money, I'm coming after it, because I'm here to protect the pro members and the people that paid for that education to be able to display that. It's not something we're going to take lightly at all.
Yeah, I mean, he's committing. It sounds like maybe not just a trademark infringement, which represents that he kind of has your blessing that his services come from you somehow, but arguably, right? And you would want to talk to an attorney about this, but it might also be some kind of fraud, right? Because if it represents a certification, then he's kind of helping these people represent that they have a certification that they don't actually have.
Right. I hadn't thought about the fraud lines of it, and that's, I mean, even though that should be common sense, right? We're getting hit by the spam bots today.
The spam bots are coming. Yep. Yeah. Oh well. Well, I mean, okay, it's going to depend a little bit also on whether his customers actually believed that, right? Whether his customers actually believed that these people were certified and they relied on that certification, and then it turned out to be false. But I don't know. That's why you're going to want to talk to an attorney about the specific facts,
right?
Because there's probably more information there that we don't want to be just waving around in a public space.
Exactly.
So, because then you would lose your confidentiality. Attorney-client privilege. So
exactly, and we don't want to do that.
Right, exactly. So let's see.
Let's see.
I answered all the questions so far. There was another thought. There was something.
Well, for me, a lot of it, because I think going back and looking at some of what we deal with on a daily basis, really, again, goes back to that whole, if you're going to be, look, and Landon Shagan and I talk about it, Vitali and I talk, I mean, it's something where it seems to happen all the time in this industry, where there are just so many people using the same business name or a likeness of the business. Veterans Pressure Washing will be a good one, right? A lot of people use the name Veterans Pressure Wash, Veterans Soft Wash, Veterans Exterior Cleaning, Veterans Window Washing Service, Veterans Window Cleaning. You know, all of these are being used, and a lot of the logos are very similar because you use the American flag as part of the veterans thing and theme. And so there are so many of those out there that one of the things I think that you need to keep in mind is, does the representation of that, is it a are the other companies out there doing a good job, or are they doing a bad job? Because using a similar name can do good things for you, and it can also do bad things for you if the other company out there, we see it all the time, where companies will take and they will alter a name to be somewhat close to the other name because they want to build off of their popularity. And so if it's not a copyright infringement or a trademark infringement, it still could be a really bad idea.
Well, okay, but here's the thing. With a trademark, okay, the standard is not is it an exact match? The standard is likelihood of confusion. So the trademark office will look at specifically, is this logo similar enough to another one out there that customers could be confused? Mm-hmm. Okay, so for example, right, I applied once for a trademark on Blackfin and got rejected because there was already a Bluefin out there. They both start with B. Apparently that makes confusion likely. They were in the exact same industry though. That's also one of the big factors. Mm-hmm. We once applied for a trademark on Epic Pilates and got rejected because there was already an Epic Yoga out there. Right. And let's see. I don't know.
That's why it's important to file your trademarks, right? Because if it's already out there, it makes it so much easier to defend it and to stop others from using it.
But okay, yeah. But so the point that I was also working towards was spaces and like one extra letter, that kind of thing, or taking an image and flipping it, aren't necessarily going to prevent it from being a trademark violation, right? Mm-hmm. If you have so what was the other one earlier? Ultra hunk, yeah. So so if you're trying to trademark ultra hunk, it doesn't really matter whether it's all one word or whether it's two. People are still going to look at that. The trademark office is still going to compare that to any other ultra hunk trademark out there, whether it's one word or two. And, or, you know, if there were a trademark out there that was like ultra hunks, then they're still going to look at that and say, well, this is essentially the same. Mm-hmm. So there is a little bit of wiggle room. You may trademark one specific thing for one specific good or service. There's a little bit of protection around that too, though. It's not just like you get exactly this with exactly this. If the service is similar enough that someone might be confused, or the name is similar enough that someone might be confused, theoretically, you can still go after them for trademark infringement.
And I guess this is kind of where it goes, and where you have to think about it. So I'm going to use so the question here, GA Pro Wash LLC. I'm gonna play on that a little bit, okay, before I get into that question. But let's say, for example, that it's GA Pro Wash, right? And GA Pro Wash is a pressure washing service, and located in Georgia. Okay, so she copyrights and trademarks and does everything that she needs to do, and she does it correctly. Okay, go ahead.
It's going to be hard to get a trademark on that. I can tell you right now, because it's geographically descriptive. and it's descriptive of what she does, there's nothing distinctive in there. So it's just a location, right? You can't trademark just a location because then there could only be one pro wash in all of Georgia, right? Mm-hmm. And you can't trademark, well, okay, pro wash maybe, but probably not, because really the wash just describes what you do. So could you get a trademark on Georgia Pro Wash? I'm not sure, right? Ultimately it would be up to the U.S. Patent and Trademark Office. But if I had a client who was trying to get a trademark on that, I would say you need to add another word. You need to add something that's more distinct to you, right? So the best trademarks, there's kind of a sliding scale, right? It's like a seesaw of descriptive versus distinctive. If it's purely descriptive, if it just tells other people what you do, you can't get a trademark on it. If it's just descriptive, right, it doesn't tell people at all what you do, it's just a name like Xerox, then it's very easy to get a trademark on it because it's purely descriptive. The problem is you want your clients, you want your customers to be able to look at the name and go, oh yeah, I know what they do, right? So one of the best ways that I know of to get around that is you have a name that's descriptive, or that's distinctive, right? That it's just like Xerox or whatever. Argent Place Law. What does Argent Place mean? Well, it has nothing to do with law, really, right? Argent is Latin for silver, place is place, so really we're the money place. But but it doesn't really tell you what we do, right? So you have a distinctive name and you have a descriptive tagline.
So right? You're saying for her,
law firm for entrepreneurs.
So for her, she couldn't get on Georgia or GA Pro Wash or Georgia Pro Wash, but she might be able to.
So. Okay. She'll want to check. She'll want to check with a lawyer, right?
But to make it easier, it would be better if she did GA Pro Wash, the female washers for you.
I mean, pick a random word almost, right? Like I've seen Eagle Wash, I've seen Laser Wash, you could, so you might not pick one of those words, but I don't know, like, I don't know, you pick a random word, right? Courage Wash or something, anything that like doesn't,
instead of Georgia or GA.
Well, you can have that in there too, right? Like it doesn't kill it to be able to say that. They might ask you to disclaim that part. They might ask you to say, I can only protect these words in this context.
And that's kind of where I was going, because like if there is let's say that she were successful in GA Pro Wash or Georgia Pro Wash, either way, GA with a dash or without. Let's say that she were successful in that, okay? That's only going to be for a category. And just where you correct me if I'm wrong, because let's say, for example, that a mouthwash company comes out and says, hey, we've got GA Pro Wash, which is a mouthwash. So it's a completely different category and not a copyright or trademark or any kind of infringement, because it's completely different. Is that correct?
Well, I mean, that's why the trademark is usually tied to a set of goods or services, right? Mm-hmm. Right. So here, so the mouthwash is a good. It's a product, right? It's not a service.
Right.
That the what we were talking about before was a service, pressure washing. So I don't think that those trademarks would necessarily collide.
Right. And that's my point. Somebody else could use a trademark different.
They can use, I mean,
because it's completely different.
There was a big fight. So Apple, right, started doing Apple Music when they got into iTunes, when they started selling things through the music store, the iTunes store. Apple was doing music, right? And they expanded all over the world, and they didn't have a lot of problems until they got to England, where they ran into Apple Records, which is the company that the record label that the Beatles used.
Mm-hmm.
Right? So then they had to cut a deal with Apple Records because it was two Apples both doing music stuff.
Oh, wow.
Yeah. So there's, I mean, you can have these kinds of fights where like someone was using a name for one thing and someone else was using the same name for something else. And then one of them starts to expand. They start to creep over into the other's industry. And then all of a sudden a fight happens because now they're trying, now you've got these two very different companies trying to use the same name.
Mm-hmm. Exactly. All right. So Stephen Atkins says, Chinese steal from people all the time. I have a family that are a corp trademark lawyers. Unless you have big bucks to go after someone, it's a waste of time. I agree and disagree with that statement because if you get I think it would be hard to grab money from a Chinese company. I don't know. But if they're a local U.S. company, and in our industry, in our service industry, I don't think you're going to run into that problem, or you won't run into that problem much. Though I'm going to make myself a note because a very important topic that I think Ryan and I will talk about tomorrow as well. I want to make sure I do this. Shoot, I started talking and I forgot it. That's what happens when you get older, right?
Well, okay, let's see. So Chinese trademark lawyer. Okay, so you agree and disagree about the ability.
I mean, because there's so many. There's nobody that from China really that's going to be trying to infringe in our industry. You know, trying to argue with us on a local level. I guess is my point. That's why I disagree with it, because
in
it's
your
just not going to happen on the local level.
Yeah, and I would also agree and disagree that this is. I mean, so besides the industry problem, right? You're probably not going to have a Chinese pressure washing service advertising in the United States. That's probably not going to be a problem. But even if so.
Yeah, and he has clarified too about. I mean, that would work on a product.
Okay. Yes. Products.
Not a service.
No. So they do that all the time, and it is hard to do anything about that. Like there are people we've had potential clients come to us and say, "Hey, someone lifted my entire product description and images and everything and used it to create their own listing on Amazon, and they're undercutting me and selling the same thing that I'm selling except cheaper. Is there anything that we can do about that?" And that's, China. There are unfortunately a lot of the Chinese. Are kind of cunning. They have this mentality of almost kind of, well, what do the rules say? Can we get around the rules? And that's, I guess, kind of a good thing and kind of a bad thing. It's a good thing for us, at least, because if they just did things legitimately, they probably would have already have passed us economically by now. But they're too busy trying to undercut each other to actually succeed. So, but okay, so yes, it is very hard typically to enforce anything against a Chinese company or to go after a Chinese company for money. Pretty much you would have to have friends in the Chinese government somewhere, somehow.
In order to do anything, because otherwise it's pointless, yeah.
Yeah. So that said, there is one tactic you can still sort of use if you really want to put forth the time and effort, and that is to have a trademark, a copyright, whatever intellectual property protections you can, because then, let's say that they go listing this or that or something else on Facebook, Twitter, Amazon, whatever. If they violate your trademark, you can strike down, you can report that listing, report that user, report whatever, and Amazon will get rid of them. Now, they'll probably just create another account and try again.
And that's the more painful part for them.
Yeah. But, I mean, if you really want to play whack-a-mole, you can. You can try.
Because it's the same thing. Look, it's the same thing with all the Chinese spam that we're getting in the bot section over there, right? I mean, I block them, and then they go in, they go through another account, and they come back in, and they put their sex spam up again, right? And so I got to keep going and whacking the mole, which is funny because we're talking about a sex thing anyhow. But so, that's how they do stuff. It would be very difficult to continually get past them.
It's an arms race, right? It's, they show up over here, you knock it down. They show up over there, you knock it down.
Goes back and forth. So GA Pro Wash popped back in again and said, "Oh, okay, what if I went with our area code, soft washing or pressure washing, and can I get a GA Pro Wash LLC logo copyrighted? Great information, and thank you for your time today."
Okay, you're talking about trademark, not copyright.
And that's an important distinction because there's between the two, and I get them confused all the time.
Okay, I'll back up just a little bit then and talk very briefly about the differences between the two. Mm-hmm. I'm sorry, I'm not going to answer your question because now we're getting into the specifics, the details, the facts of your specific situation. Mm-hmm. And I would rather, if I give you a half answer,
an attorney,
if I give you a half answer, that's likely to do damage. Yes, mm-hmm. If I give you just a half answer, I could just as easily do damage as actually help you. I don't want to give you just a half answer, but I also can't give you a full answer because you're not paying me to do that. So, sorry. Okay, so very briefly then, differences between copyright and trademark. So copyright is typically more for like an artistic thing, okay? If you create a work of art, if you take a picture, if you paint
and pictures are what's big in this industry.
If you design a logo, right? Okay, there we go. Yeah. So like before and after pictures, whoever takes that picture, they own the copyright, unless they're an employee working for your power washing company and your employment contract with them says that whenever you take pictures, I own them. Okay, so know what's in your employment contract. Have someone have a lawyer look at your employment contract. But so the before and after pictures, those are copyrighted. They belong to whoever took the picture usually. And so nobody else is allowed to use those. And so nobody else is allowed to use those. And if you register them, then you can go after whoever does use them for the statutory damages, right? Up to $150,000 per infringement. So copyright can apply to a picture. It can also apply to like a logo or a graphic. If you have a graphic designer make something for you, then then that's also copyrighted, right? Because it's an image, it's a graphic, it's a creative work. So copyright has to do with like the thing itself, right? The picture, the image, the whatever itself. The trademark has to do with identifying the source of a good or service. Okay, it has to do more with your company's identity. So it is usually a logo or a phrase. Sometimes it's a tagline. Occasionally it's other things, right? It could be a color, right? If a truck pulls up outside to deliver a package and it's brown, you know which company I'm talking about. Yes, yeah. I don't have to tell you a name. You know which company I'm talking about because it's a service, right? It's a good or service tied to an identifying factor. Brown. Now, if that doesn't apply necessarily where it's a functional attribute of the product or service, right? If red actually made a car go faster, you wouldn't be able to trademark red
because it makes the car go faster.
Because it actually affects the performance of the device or the thing, right? Mm-hmm. The good or service, right? So you can't trademark like, we use this special nozzle on our pressure washing that allows us to do it 10% faster or whatever. You can't trademark that because that's not.
That's a patent thing.
Yeah, that's not just an identifying thing. That's like an actual
functional thing.
And
that's where we get away from the copyright and the trademark, and then we get into the patent side.
Over into patents,
and how they all have to kind of flow and do different
things. I'm not going to get too far into patents. Patents protect a device usually or a design that allows your device to actually, whatever your device is, to do something that other devices can't do the same way.
Exactly.
So,
and so real
anyway.
quick, just to back up a little bit, GA Pro Wash, just so you know, Mr. Roland's phone number is right there on the screen, 703-539-2518, extension number 3. You could talk to him there and create that attorney-client relationship. He can't answer. He can't be very specific on certain things and create which actually could get you in trouble, if I'm not mistaken, because if you give, like you were saying, a half of an answer and she relies on that, I could see where there could be an issue there. Maybe I'm wrong.
Well, yeah, and I don't want her to take something I've said and go off in this direction in reliance on that, and then get into any kind of trouble. Even though theoretically that trouble could also come back on me. So,
which is something that we do a lot in this industry. When we're talking about, a lot of times, somebody will say you do something this way, and somebody will go out and they'll do it that way, and it'll be the wrong way because they're in a different area, different climate, different this, different that, different substructure, all these different things. So it doesn't work. And so you have to have all of the information when you are applying whatever that knowledge is that you're gathering, whether it's knowledge about soft washing or about the legal aspects of a certain thing, copyright or a trademark or whatever it happens to be.
So this isn't legal advice. This is more business advice. But the guideline that I try to use when I'm trying to figure out whose advice will I actually take, whose advice do I want to trust and listen to, I'll typically look at what kinds of results they've created, right? If they're in about the same place as me in life, they probably don't know anything more than I do, really. If they're significantly more successful than I am, if I would kind of almost trade places with them, then I will listen to their advice. But if it's just somebody else who's kind of in the same industry, kind of like a peer in the same spot as you, I would take their advice with a grain of salt because they may or may not know any more than you do.
Mm-hmm. Yeah, and that's, again, that's important because we do that a lot in this industry where we're getting advice and we're giving advice, and you have to gauge who and where that's coming from. And I think if I'm a betting man, of which I am, I would be betting that most people, when they're looking at the advice that they're getting, they're not even looking at who they're getting it from, or they're looking at somebody that just happens to be online a lot. And so you recognize them a lot, but does that mean that they've done anything with their business? Or are they just online a lot because they have no business and, that kind of a thing. So those are things to take into consideration.
People make life-altering decisions all the time based on something they read on Google. Mm-hmm. It's kind of scary.
Yeah. Especially in today's climate and the way things are going. So. So here's an interesting thing that, and again, Ryan and I will talk about some of this stuff tomorrow, I'm sure, but I want to get kind of a legal perspective on it, if you would. So, and I think it's a Home Advisor, or it's one of those kinds of things, big company, right? And which I believe they're being sued for different things, whatever. But there are companies out there, and I'm gonna pick on you and your name, but let's say it's Roland's Pressure Washing, and Roland's Pressure Washing will be in Santa Fe, it'll be in Baton Rouge, it'll be in Tampa, they're being advertised in all of these areas. And we have a lot of guys that get upset with this because there's no actual business there. Okay. The purpose of the advertisement is so that me as a consumer, I'm looking for, pressure washing in Baton Rouge, and this company that is Roland's Pressure Washing pops up because they're paying to advertise and be number one. That leads you back to, okay, so I call their 800 number, but really what they're trying to do is they're trying to sell you a service, and they're trying to sell the contractor a service of, hey, we're number one on Google everywhere, and then they sell those leads. You see what I mean? So
yeah, lead generation.
Exactly, and that's all they're there for is lead generation. Are there any thoughts on something like that?
As in, is what they're doing legal, or I
Yeah,
mean,
because a lot of people are, and this is something where, I mean, there's a whole lot of speculation going on here, and just reiterating that none of this is legal advice or any of that kind of stuff. It's just mere thoughts. But yeah, we get a lot of people asking, man, is this even legal? It may not be ethical and all these kinds of things, but it must be legal for them to do because they're doing it and they're a big company. But they're truly, in my mind's eye, the companies doing that sort of thing, they're misleading the consumers into thinking they're an actual business doing that service, but they do not own a business doing that service. They're using that to funnel it to
we
their other
had
stuff.
we had a client come to us not too long ago who actually had kind of a problem like that. He had a trademark, he or she, I don't even remember who the client was exactly, but they had a trademark. Who they had a trademark, and then someone had done something that kind of violated their trademark, and it was one of these lead gen companies, or it was through one of these lead gen companies. And so in order for us to even figure out who actually did the infringing, we would have needed to kind of jump through some hoops. That said, okay, so these lead gen companies, I mean, theoretically, yeah, they can do whatever they want. They can advertise a service that they don't actually provide. They can, if they want, they can advertise over here and then be advertising on the other side, like, hey, you want some leads, come pay us and we'll pass these leads on to you. That's just being a middleman. You can do that. I guess the question, the first question in my head is going to be, this lead gen service, what kinds of claims are they making, right? Because they could make some they could be honest about the way they do it, or they could make claims that are maybe not necessarily honest. And if they go misrepresenting things as part of their marketing and their advertising,
I don't think they're doing that. I mean, I think they're,
yeah.
Well, okay. Other than they're saying, we're the best pressure washing service in the area, which could be a misrepresentation because they don't even actually pressure wash in the area.
Well, and yeah, so okay, theoretically, right, it's hard to prove fraud. It's harder to prove fraud than it is to prove most other kinds of legal cases, legal actions. But theoretically, if they really misrepresent themselves, then it could be fraud. Other than that,
I think that one of them might be getting sued for that, but I'm not positive.
Well, okay, and I mean, that's just because they're getting sued for it doesn't mean it actually happened.
Right.
I'm sorry. I'm going to be a little bit skeptical there. A lot of people are like, well, but if they got sued for it, they must be, they're walking too close to the line. No, not necessarily. There are a lot of people out there who are just kind of happy to pull the trigger. So I don't know. It's actually tangent. You know where most like 35 or 40% of all bar complaints come from? They come from people regarding family law disputes, divorces, and child custody stuff. And it's not because the person, it's not, it's
because they lost.
Yeah, exactly. It's not because 35% of all divorce lawyers are bad lawyers or anything. It's because people are upset. And they just, actually
you lose your perception, your proper perspective.
Yeah, exactly. It's like you get out of perspective, right? And there was a study done also that found that most of the doctors who get sued for malpractice are neither better nor worse than any other doctors who don't get sued for malpractice. They just have worse bedside manners. So really, the thing that ticks people off and gets them to sue you is not how good your service is or bad. It's how well you communicate with them and how you make them feel about the experience.
And that right there is, if I ended the day on any piece of advice, that would be it. Because I'm going to tell you what, I cannot tell you enough how much your bedside manner affects everything. If you have a complaint, you deal with it and you address it right away. You deal with it respectfully. Even if you disagree with it, you address it. You address it professionally, respectfully, all that kind of stuff. Because your attitude, it can greatly affect the actions and reactions of the person that you are that you're having the issue with. How to win friends and influence people. Yep. Exactly. There you go. Yeah. Yeah. Your bedside manner, your attitude, your that literally affects, I mean, or can affect anything and everything that you do. And excuse me. Sometimes people ask how it was that I was so successful in my businesses. And a lot of it boils down to my attitude and my way of doing things. So first of all, I do things to protect my companies, like I file trademarks and copyrights and those kinds of things to protect what it is that I'm trying to build. Okay, and then secondly, just my attitude towards clients and how I interact and deal with them is a key point. You should do that kind of a thing. And it's not bad to have lawyers in your back pocket, even though, look, don't tell Roland, I don't like attorneys. Don't say nothing to Roland, y'all. Just so you know that. No, I mean, but the fact of the matter is, they become a necessary evil, if you would, as it's saying. And just like with everything else, you want to find a good attorney. You want to get good advice. You want to, these kinds of things, and know that there's a time. And the importance of let's go this direction. We're running about an hour and 15 minutes into it. Let's go this direction. Why is it important to? I'm going to use the words hire an attorney when you're starting a business. Why is it so important to do that? What are the big pitfalls of not doing it?
Well, basically, being an entrepreneur is about two things, right? It's about prioritization, and risk management, right? When you are going to take, so how do you make money as an entrepreneur? You take risks, but you take calculated risks. You don't just take crazy, stupid risks. You take calculated risks. So ideally, whenever you take on a risk, someone should be paying you to do that. And whenever you want to mitigate a risk, right, reduce the risk, you pay someone else to take care of something, ideally an expert. So if you want to make sure that your LLC is actually set up and in place so that if there's a lawsuit down the road, your personal stuff isn't on the line. If you want to make sure that you have a good employment contract with your employees so that any before and after pictures they take actually belong to you and they don't do like one of our clients. One of our clients owns a nail salon, and he always had his nail people take pictures of nails that they had done, so that he could, and give them to him so that he could post them online. But then they would also take the pictures that they had taken and post them on their own private Instagrams and use those to attract his customers away when they left. Right. So if you have a good employment contract, then the pictures will actually belong to you. And if one of your employees goes using the pictures to advertise themselves or to advertise somebody else, you can come after them and say, hey, wait a minute, those are my pictures. All of these things, all of these risks are risks that an expert can help you mitigate, right? And a lawyer, necessary evil, right? Yes, I recognize they're expensive, but on the other hand, if I had a reasonable sum of money for every time that a client had come to me and asked me about something and said, it's too expensive, and then they came back a couple years later and said,
it's way more expensive.
It said, hey, what about this situation? And I'm like, this is going to cost you tens of thousands of dollars. right? It would have cost them a tenth or less of what it's now costing them because they didn't do they went looking for the medicine instead of the vitamin, right? They went looking for the aftercare instead of the preventative care.
Mm-hmm.
So,
and that's a good analogy because it's why insurance companies will typically pay for preventative care because they want to prevent the greater sickness or the greater legal battle, if you would, in the future, because they know that they can mitigate their risks and they save billions of dollars by doing that.
yeah, exactly. So why hire an expert? Well, because if you want to make sure, so priority, now we're going to go back to the priority management, right? I already talked about risk management. Now we're going to go back to priority management. You have time and you have money. You only have so much of each. There's always going to be more that needs to be done than you have time or money to do. But which one's more important, time or money? That depends, right? It depends on the context. It depends on what you're talking about, what we're doing. But you want to be able to hand some of the stuff off to someone else who can take care of it for you without you having to think about it, right? Instead of you're having to spend 3 hours, 5 hours trying to figure out how do I trademark my own logo, you hire someone, they ask you a battery of questions for 30 minutes over the phone, and then and then 2 days later you get an email saying, here's the draft application I put together. Take a look through it and tell me if you see anything that looks wrong. And then it's submitted. You know, once you approve it, it's submitted, and then you get, and then that's it, basically, right? Then I keep tabs on it. I come back to you 3 months, 6 months, whatever, however long later, and I tell you, here's what's going on with it. It's not just, I guess it's peace of mind, right? It's not just, you have to decide what's more valuable to you in each instance, time or money. Because a lot of stuff you can't do on your own, but you don't have to do everything on your own. And you don't always know what you don't know either.
We got the spam bot or the Chinese spammers tried to get in there one last time. I think we're almost an hour and a half into it, and I think it'd be a good time to wrap it up. Any parting thoughts that you have, or anything you want to say as we part and end it for the day?
I guess along a similar vein as earlier. Business, so it's good to know. So we were talking earlier about bedside manner, right? And dealing with people. Mm-hmm. It's really good to be able to deal with people. It's also really good to have good technical skills, right? Good legal skills. You want to be good at your game, your business, mm-hmm. but you also want to be good at how you structure your business. Okay, so I guess to give you one more example, George Lucas did not become a billionaire because of Star Wars directly. Okay. George Lucas he created Star Wars at a time and in an industry where sci-fi movies were considered money losers. Okay. So when he said, I've got this idea for Star Wars, I want to produce it, he said, I want the rights. When I make this movie, I want the rights. And the studio basically said, well, sci-fi never makes money anyway. Sure, we'll give you the rights. So when Star Wars turned out to be a surprisingly big hit, yes, they had to come to him. We want you to do another Star Wars movie. So what's he asked for this time? He says, well, okay, but I want the merchandising rights. And they said, nobody makes money in merchandising. Sure, we'll give them the rights. And that was in a time when merchandising was usually not done like en masse. They didn't make action figures of everybody and distribute them at the same time as the movie was popular. It was kind of a more after the fact kind of a thing. So he then proceeded to structure things, right? He got the merchandising rights, and then he proceeded to control the way that the merchandising was done, and it was merchandised all at the same time as that the movies were popular. And so George Lucas did not become a billionaire because of Star Wars. He became a billionaire because of the merchandise.
And all the stuff that he's got associated with Star Wars.
And all the stuff, the toy lightsabers and the toy and the Wookiee costumes and all the other stuff, right?
All of it.
So think about that for a second. Yes, it's good to be good at your game. Yes, it's good to be good with people. But if you know what you're doing structure-wise, that can make you a lot of money.
Especially if your thoughts or your plans are to later on franchise down the road or do something along those lines, it's better to get everything set up correctly ahead of time, even though it costs you a little bit of money up front. It's just a better thing to do. So, Mr. Roland, certainly appreciate your time today. And hey, y'all, if you have any questions for Roland, business questions, copyright or trademark questions, give him a call. Again, it's argentlaw.com, I believe it is, correct?
Argentplacelaw.com. Yeah.
Argentplacelaw.com. Or you can reach him by phone, and I will put that up one more time and leave it there. Or you can give him a call. There's his phone number. Give him a call and touch bases with him. Hang out for a couple seconds as we finish this off, and we'll see y'all tomorrow night because it's Sunday right now. So remember, Ryan McGowan will be our special guest tomorrow, and we'll have some colorful discussions, I'm sure, with Ryan. Peace out, y'all.